And it's actually a great opportunity for me to talk about a paper that I co-authored with one of my former students who's now a practicing attorney about 5 years ago for a conference at the University of Pennsylvania. And it was recently just published this spring. And because of the pandemic, we never got to really do a program around it. So I appreciate the opportunity to talk about it today. This is a bit of a merge of the weird merge of my two areas of expertise. I started out at a firm doing half my time with the government contracts practice, primarily focusing on small business issues, and then half my time in the white collar crime practice group doing Foreign Corrupt Practices Act. So the this idea was born out of my two areas of expertise, which really stems from the course I teach. For those of you that don't know me well enough or know my background, I teach a course at GW Law School in anti-corruption and compliance that's been around for a decade. And it is part of the law school's government procurement law program. So it has a focus on anti-corruption and compliance, but also in the context of procurement. So we focus on things in addition to what we traditionally think of corruption, but also things like the False Claims Act and debarment and Procurement Integrity Act, other things that are a bit more specific to government procurement than just the general anti-corruption statutes that many of the members here are more familiar with. About 5 years ago, I was on my way commuting to work. Does everybody remember commuting? How adorable that used to be when we also used to commute and not just live in our homes. And I had this idea, I think a lot of the conversation around global anti-corruption and compliance issues focuses on what's happening with large companies. The focus tends to be on the big settlements and the big enforcement activities and what the big guys are doing when it comes to ethics and compliance. And there's not a lot of focus on what's happening with the small entities when it comes to this conversation. And so I started thinking about small companies and the role that they play, particularly in procurement systems, not just the United States, but also internationally. And I know how much they struggle with these issues. And I know how much they struggle, not just with compliance, but also with corruption issues. And I knew there had to be a better path forward. So I'm going to give some background on this because I know that there are some folks here from at least one from the ABA Public Contract Section Small Business Committee. And then this is the International Anti-Corruption Committee. So I'm going to give a little background on both of those issues. So if some of this seems a little 101 to you when I get to your section, I apologize, but it's just in case everybody has different backgrounds. So for the folks that are less familiar with the corruption, I'm giving you a very quick 101 on the anti-corruption and compliance landscape. So really since post 9/11, there's been a sea change in the way that the US government approaches corruption. The Foreign Corrupt Practices Act, which prohibits the bribery of foreign government officials, has been around since the late 70s, but it's not been really enforced since around this post 9/11 period, around 2003, 2004. The US was alone in the world with legislation like this for about 25 years, but with the passage of multilateral conventions such as the OECD Anti-Bribery Convention and the UN Convention Against Corruption, we really started to see a change in the way that governments approached it. Now we have things like the UK Bribery Act, Brazil's Clean Company Act, even France's Susceptible, among many others, that prohibit the bribery of foreign government officials. But they also either require or strongly encourage companies to maintain robust anti-corruption compliance programs and to also maintain robust internal controls. What's been fascinating to me teaching this over the past 10 years, but of course watching it initially as a practitioner, and those of us on this committee are familiar with, we've really seen an international consensus develop when it comes to best practices, when it comes to compliance. The words all differ a little bit, but the standards are pretty much the same. And so we see guides now coming out of OECD, United Nations, and then country specific, which again mirror what we see globally from the United States and the UK and France, and even not NGOs like the World Bank and Transparency International that have these kind of compliance programs. And now we've seen in the commercial sector that state-of-the-art compliance programs, those of you particularly that are here today from companies, know that these have become a norm in the commercial sector. But in the government procurement sector, having a robust compliance program has always been a necessity because of the numerous regulations and regimes that they must comply with in order to receive these government contracts. And in fact, in the US system, contractors of a certain size are legally obligated to maintain an internal control system, to provide ethics and compliance training, and then even most contractors are required to have a code of business ethics and conduct. So while the government, and particularly the US government's largest contractors, have invested heavily in these robust and sophisticated compliance programs, the smallest contractors lag significantly far behind it. It's not even close. Now, they are required by the federal acquisition regulations to maintain a code of business ethics and conduct, but they're exempt from establishing a compliance program and internal control system like the larger contractors are. It's recommended that they have them, but what we know is that this places a significant financial burden on small businesses. And indeed, when the rule was passed for larger companies, there was significant pushback from organizations that represent contractors that this not be applicable to small businesses because of the burdens that it would place on them. Now, let me be clear, it's not limited to the United States. The UN and OECD have reported on this fairly extensively, and they found that SMEs, or small or mid-sized enterprises, so they use a bit of a different term than we typically use in the United States, struggle more than large firms with handling these regulatory requirements. We know this. And they've also been significantly slower to implement or acknowledge the growing best practices in this area. Again, fairly obvious to most of us that practice in this area. And the most common and obvious reason for this is cost. Most small businesses spend most of their resources on just trying to get to the next day. They see compliance as a luxury and not an essential aspect of doing business. And the cost is actually quite disproportionate. There was a Small Business Administration report in 2010 that found, and it's clearly outdated now, but it's the only report I know that has accounted for this data, that found that small firms with less than 20 employees paid on average around $10,000 per employee to comply with all federal regulations, while firms with between 20 and 499 employees paid on average $7,000 per employee to comply. So it's a disproportionate cost borne by small companies. And in fact, we see that sometimes small businesses find working outside regulatory requirements to be more profitable. We also know that these hallmarks of best compliance programs that many countries and international organizations promote are designed with large companies in mind, not with the small companies in mind. But even though that this is the fact of the way of life, it's doesn't reduce the risk that small companies face. They have the same corruption and compliance risk, but they have that less of a level of protection because they don't have this investment in ethics and compliance. And let me be clear, fraud and corruption are huge problems for small entities. A UN report found that small businesses rank highest in occupational fraud frequency, the biggest factor, lack of internal controls. The Association of Certified Fraud Examiners have reported that small businesses rank of having the highest rate of fraud as compared to large businesses, pointing primarily to owners not having proper tools or training to prevent fraud. We've also seen a survey that in the developing world and countries in transition, a business environment and enterprise performance survey found that more than 70% of small and mid-sized enterprises, or SMEs, in transition economies perceive corruption as an impediment to their business. The data strongly suggests that the smaller the firm is, the more likely it is to be affected by corruption. More SMEs than larger businesses believe corruption is part of the way things work in countries. More SMEs than large enterprises believe or have they've been asked for bribes in order to obtain things like licenses and permits than their large counterparts. And more SMEs pay a higher percentage of annual revenues and bribes to public officials than their larger counterparts. So it really is lopsided when it comes to these issues on corruption and fraud. Now, some other additional reporting done by the United Nations and the World Bank have pointed to various reasons why small companies are more susceptible to corruption and fraud. The first being their structure, and in addition to cost, which I already mentioned. Often there's informality and closer relationships in small companies, which can create a greater culture where corruption is tolerated. Oftentimes, small or mid-sized enterprises have a shorter term vision. So larger companies may have a long-term vision where they see the long-term drawbacks and costs associated with corruption. But SMEs have to think about the short term, and there's a tendency to only see the short-term benefits of corruption rather than the long-term benefits. There's the potential lost revenue because of shortage of capital and smaller profit margins. Smaller companies can't always afford to refuse to pay the bribes that larger companies can do. They are also less powerful and have less influence than larger companies, and less bargaining power to push back against officials requesting bribes. As far as structure, think about it. Large companies may be public. Obviously, they're going to have additional constraints, and they are subject to public perception and reporting requirements. Small, mid-sized enterprises are often tightly held. They don't have similar concerns, and of course, there's the landscape. The more red tape and bureaucracy, which creates delays, creates financial costs for small enterprises, which are disproportionately higher for them than they are for large businesses. So all of these things come together to create this large atmosphere of fraud and corruption, or at least a large risk of fraud corruption for small and mid-sized enterprises. Now, this is a problem obviously for society and governments, but it's also a problem for large contractors. For those of us in the Anti-Corruption Committee, we are quite aware that the statutes that regulate the bribery of foreign government officials typically have fairly vast liability standards, at least particularly in the United States, so that commercial entities relying on small business suppliers are often at risk and can be held liable for their shortcomings and their corruption. Now, this risk is particularly acute in the US procurement regime, where it's a policy of the United States that small businesses have the maximum practical opportunity to participate in providing goods and services to the US federal government. So it's an increased risk in the US procurement system. Now, the goals behind this in the US procurement system are, and this is just to name a few, to preserve free competitive enterprise. And of course, the US procurement system places an emphasis on promoting social policies through its small business priorities. And that's things like promoting service disabled veteran-owned businesses, or small disadvantaged businesses, or even women-owned businesses. So there's a lot of social policies behind the rationale for why the US government makes small businesses and small business contracting a priority. Congress has memorialized its support for this through various statutes. The primary statute requiring agencies to meet certain small business contracting goals, specifically 23% small business contracting goal per year. And to meet this, the contracting officers are often required to reserve a certain percentage of total contracts so that only small businesses now may bid on them. Now, also to meet those goals, large prime contractors under certain circumstances must also preference small businesses as their subcontractors to help those agencies meet those goals. And indeed, defense contractors sometimes even have enhanced small business obligations. So the fate of large enterprises, is particularly in the US procurement system, are tied to the success of these small companies that they're required to use to promote these policies of the US government. So this again creates even greater risk within the US procurement system. Now, despite the US government's commitment to small businesses, we often find that they are excluded from procurement opportunities and excluded from the entire government procurement system more frequently than large businesses. And this rate of exclusion holds true not only in the US system, but also in the World Bank system. So we know that small businesses in the US system are often more susceptible to exclusion. That would be debarment or even suspension, because of their limited knowledge of regulatory requirements and often less developed compliance and ethics programs. It's also the case that once misconduct is discovered, we know small businesses lack the resources to respond to and remediate the harm like large businesses. And the statistics really show this. Now, in the US system, there is a report often released annually. It's a little bit behind right now. I'm blaming COVID right now for that. It could be another reason, but I believe it's probably COVID. Where the Interagency Suspension and Debarment Committee within the federal system releases a report to Congress every year tracking suspension and debarment statistics for the federal government and federal agencies. And while it does that on kind of a general level, showing general debarment and suspension numbers, it doesn't break them down by individuals or small companies or large companies. It doesn't break it down by size. But I have to give credit to David Robbins, who's a partner in the law firm of Jenner and Block, and his colleagues, because for the past few years, he's gone into various databases to look and really hone in on the data, making up these statistics to try to figure out which of these exclusions apply to large companies, which of the exclusions apply to individuals, and which of these exclusions apply to small companies. So I'm grateful to him for this research because nobody else seems to have done it, not even the federal government. And what he's found is actually quite shocking. A significant portion of US firms that have been excluded have revenue under $2 million per year. And an overwhelming majority of the excluded firms have revenues under 5 million. And even more shocking, in fiscal year 2019, nine agencies, 100% of the excluded firms were small, with other agencies hovering around the 70 to 90 percentile. So 70, 90% of their exclusions were small companies compared to large entities. So that's a really shocking statistic to me. And it's no better when you look at the World Bank system. In the World Bank system, when it comes to SMEs or small or mid-sized enterprises, debarment is far more likely. And a lot of that reason is that they're far more likely to default. They don't even engage in the debarment process, whether it's because they don't understand, it's too intimidating, the cost is too prohibitive, or they just quite frankly say, you know what, I don't have enough World Bank business to make this worth my time. They don't respond and they effectively default, basically resulting in their exclusion. And they oftentimes will agree, if they've even engaged, to compliance requirements as part of their sanctions settlement, but they don't even understand what to do. So that also leads to reduced success in the system. And what's fascinating is as the World Bank has enhanced the due process available and provided greater formality to their sanctions process, it's become more complicated to the small businesses. So there's been a decreased likelihood that small businesses will actually engage in that process. So it's almost had an inverse impact on small companies as it has for those large companies that have asked for more due process in the system. Okay, so where does this leave us? You know, if we know that the US government in particular, or even the World Bank, want small businesses to work with their systems, and we know that large companies have to use them, why aren't they helping them more? Now, let me be clear, when we think about ethics and compliance obligations from the Department of Justice standpoint for settlements, I'm just using the US as an example, they often award compliance credit for companies that will provide oversight or training to their third parties. There is that expectation because of the liability standards associated under these statutes. So there is an expectation by enforcement agencies that if you are a large entity and you're contracting with suppliers, you're going to be providing oversight over these third parties and some training if necessary, or even making them comply with your own standards. But that's not the same as providing affirmative assistance to help these small entities really truly improve their own ethics and compliance systems. There's a big difference. And this is a problem where subcontractors, third parties, and suppliers have failed to invest time or resources in developing their own compliance programs. Just relying on, you know, some reporting requirements or audit procedures or just attending some training isn't quite enough. And so it's pretty rare that we see large companies, you know, their commitments to small businesses extending beyond these basic minimum requirements. So this enters my proposed solution in the paper, which I provided in the chat function. And Mark, I don't know if you still have access to it, but you may want to provide the link again because anybody who joined later in this call won't have access to that link. But it's also sent out in the email as well. So I wanted to look to an existing regime when coming up with a solution. And I looked to, in the US procurement system, what's referred to as the mentor protege assistance programs. Now, there are a few of them. There's a variety of mentor protege programs, although it's been consolidated just recently within the US procurement system. But I'm just going to use mentor protege programs globally for purposes of this discussion because I'm not going to get into the nuance here. But effectively, in the early 90s, these programs were created to provide assistance to small US government contractors to provide resources and support in the federal procurement sector. It's basically an arrangement in which mentors, which are typically successful large prime contractors, provide technical, managerial, and other business development assistance to small businesses, or what's referred to as proteges. In return for providing the assistance, the programs then provide incentives for mentor participation, such as credit towards subcontracting goals, reimbursements for mentoring costs, maybe additional evaluation points that increase a prime contractor's likelihood of winning a contract, or sometimes even annual monetary awards to mentors to prove that their support has benefited the protege. And these are just a few examples of some of the incentives that are provided to these large companies to partner with these protege firms. Now, in return for these financial incentives, the large business then trains the smaller business, on industry-specific subjects. They'll provide assistance in obtaining these government and commercial contracts, and they'll advise on issues related to contract administration, among many other things. So that is the kind of basic framework of the mentor protege program. And so thinking of this and how it's worked in the procurement system on kind of contractual and managerial guidance, I kept thinking, why don't we have a mentor protege program based on compliance? Why aren't there incentives for large government contractors, whether that's enhanced compliance credit for the Department of Justice, or even additional in the US procurement system? Why aren't there additional financial assistance or financial incentives for large government contractors to provide compliance mentoring beyond just training and oversight to these small entities, given the vast resources that they've already dedicated to their own programs? And it could be just another component of a small business protege agreement between the mentor and the protege. Why isn't there something more formalized? Why isn't there a bigger push for something like this? Because to me, I think this could really help small businesses, not only to enhance their ethics and compliance, but to reduce their fraud and corruption risks. I think that you look at large companies, they already allocate so much to their compliance functions. The cost of sharing these best practices would be quite minimal. I appreciate that large companies often review their ethics and compliance programs as proprietary, and often don't want to share some of these details. But I think the benefits can outweigh the risks in these situations. And my mentoring could include things like comprehensive reviews of a small business existing ethics and compliance program, maybe recommendations for improvements, assistance implementing compliance enhancements, training to protege firms, maybe beyond what they already provide, assistance evaluating and testing the programs, and ongoing mentorship from the large companies and their experienced ethics and compliance staff. Now, let me just say, I came up with this idea, as I said at the very beginning, on like a walk to the metro in Washington, D.C. I was just like, this is genius. This is the answer to all the problems. This is the paper that's going to be written. And I did all this, and I worked with my research assistant, and we wrote this paper, and I was getting ready to present it at the University of Pennsylvania. And it was literally the night before I was to go out to Pennsylvania, and I was just doing some digging around. I was just learning some more. And I look and I find out that apparently Lockheed Martin also had similar inspiration, perhaps not on their commute, but Lockheed Martin had created something that I had been envisioning and I just wasn't aware of it. It's now on the internet and you actually can access a summary of what they've done, but they've created what's called an ethics supplier mentoring program. And if people are interested, I'm happy to provide links to resources after this program to some of this, as well as the data I've been citing in this presentation. It includes a variety of aspects, a suite of self-serve resources for their mentees, an evaluation of the supplier's existing ethics program, live webinar series where the Lockheed Martin's ethics and compliance staff basically walk participants through the setup and implementation of each element of an effective compliance program, and then an option for one-on-one mentoring by a Lockheed Martin ethics officer. And it's really been a successful program, and their website touts a lot of the success that they've had with their suppliers and goes into greater detail about how it's worked. And I can only think that if other large and sophisticated contractors and companies could do such a thing, it could really have a great impact on not only the US procurement system, but the global procurement system and kind of global ethics and compliance landscape. Now, we know not all contractors are willing to spend the time and resources to do what Lockheed has done. And let's be clear, Lockheed is doing this voluntarily. There's no existing credit out there for this type of effort, which is why I think incentives could help, and which is why I made this proposal for this kind of more formalized ethics and compliance mentoring program.